Hi, I'm Palmer Johnson. I'm an attorney in Tulsa, Oklahoma, and welcome to my video series where I address commonly asked questions and topics that I get from my clients. And today I'm talking a little bit about um, adult guardianships and incapacitated adults. And the question is, what kind of evidence do you need in order to obtain a guardianship over an adult? Well, you're going to need evidence of incapacity. That evidence may come from a physician, it may come from a psychiatrist, it may come from a psychological evaluation, it may be somewhat um, event, related, where specific individuals can testify to their specific experiences. And it can also just simply be, um, you know, uh, straight from the doctor too, because some situations could be quite clear. If someone's in a coma, they're absolutely incapacitated at that moment. They're unable to speak for themselves. Now, they may have estate planning documents or a power of attorney that would govern how they would want certain things done or who they've nominated. But in the absence of those types of documents, then you might need to obtain an emergency or even if it's not an emergency, guardianship over an adult incapacitated family member, um, and that's the type of evidence that you're going to need. And people can have lucid moments if this is contested or the person that is the subject of the guardianship, because they're going to be entitled to notice, disagrees with it. Um, then you may have the court order an independent evaluation. They'll always appoint independent counsel for the proposed ward, and they may even appoint a guardian ad litem if it's a particularly contested, high conflict family matter where there's family members competing over who's going to serve as the guardian, to try to kind of cut through and make at least a recommendation to the court as to what is in the ward's best interest. But the primary evidence that you're going to need is going to be related to their physical and mental condition, and just simply alleging that someone is, you know 89 and has dementia, based on your lay opinion as a layperson, is not going to be sufficient. So you're going to need more than that. And if you've got a specific scenario, and somebody and the specific facts of your case is really what you need to talk to an attorney about, and they can better assess whether or not they think that you're going to meet the standards to have somebody declared incapacitated such that a guardian would be appointed over their person and estate. Um, if you would like to set up a low-cost initial consultation to talk about the facts of your specific case, you can reach me at Worth Law Office, and I would be happy to talk to you about the facts and um, likely outcome of your particular case.